ಇಬ್ಬಂದಿಯಲ್ಲಿಯೇ ದರ್ಶನ ಕಾಣೋ.
Hello, Shekhar Purna here. Garfield.Law Limited is a private entity that utilizes AI to recover unpaid bills, handle small claims related to debt collection, prepare court documents, draft legal notices, and formulate court petitions. To provide high-quality legal services to the public, promote competition in the legal profession, protect consumer interests, and accommodate new technologies and business models, allowing non-lawyers to participate in the ownership and management of legal firms under alternative business structures. The Solicitors Regulation Authority of the United Kingdom in 2025 granted the world's first official approval to Garfield.Law Limited as a fully AI-driven legal services provider to deliver officially regulated legal services. This is a historic development in the global legal arena, marking the first time a regulatory body has officially recognized a firm that provides legal services exclusively through AI. Our firm resolve is to maintain absolute and complete control over adjudication by ensuring human supervision at every stage while simultaneously adopting AI technology to complement the judicial process. As Shekhar Purna, my objective here is simply to draw everyone's attention to the view expressed by the Supreme Court of India in Civil Appeal number 11950 of 2025. The court emphasized maintaining a fine balance, neither completely rejecting AI technology during adjudication, nor entirely surrendering judicial oversight to it. I want to clarify that the purpose of this note is not to condemn the judgment, but rather to begin my commentary on its profound implications. In the aforementioned judgment, our Supreme Court observed that while the United Kingdom's order is satisfactory and reassuring, leaving artificial intelligence unregulated could allow it to infiltrate the ethics of our intellectual work. Consequently, it could very quickly make us dependent on its vast capabilities. In my opinion, this is a highly respectable and vital perspective. Beyond the judgment, there is another development that I must record here. On June 3, 2026, the Supreme Court's AI Committee released a 35-page draft blueprint on how AI should be implemented in the Indian judicial sector, seeking feedback from stakeholders and the general public. While this project is still in its nascent stages, I had officially intended to respond to it, but due to lack of time and age-related inertia, I could not do so. It is quite evident that a vision still in its preliminary phase will contain several shortcomings. It is welcoming that the court acknowledged in its judgment how the extraordinary capability of AI motivates professionals to adopt and utilize it to work smartly, efficiently, and expeditiously. In the third paragraph of the judgment, the Honorable Court highlighted that reliance on technology for the delivery of justice has never been an issue, as our courts have seamlessly adopted technologies and made them an integral part of court systems. However, the story of AI unfolding now is entirely different. In fact, it's transformative. This is because AI is not merely a tool to assist us in our work. It acts as a substitute for our own thinking, logic, and decision-making. This is precisely where we need to be most cautious. The court pointed out that the unregulated use of AI imperceptibly enters the legal profession, the judicial decision-making, and decision-making itself. I trust that the Supreme Court's AI Committee will take note of this. Another highlight of the judgment states, "Wisdom and foresight compel us to recognize the human weakness of seeking comfort by delegating responsibility to others. But if delegating the very act of thinking becomes a habit, it will have serious consequences on the core of human existence." The essence of human existence lies in the capacity to think, in discerning the difference between right and wrong, truth and untruth, virtue and vice, righteousness or dharma, and unrighteousness or adharma. To draw everyone's attention, I have prepared a direct translation of another crucial paragraph from the judgment below. Absolute and complete control over the application and use of AI is vital and mandatory. This control lies in staying 2 steps ahead of its application and making deliberate choices about when and where to apply it. We recognize that this is not a matter to be resolved merely through judicial mandates and declaratory judgments, but solely through public policy and enforceable rules and regulations. We are also aware that this process has already begun. Regulations are being debated, and after due process, they will be notified in due course. However, true success does not lie in merely framing a rule or regulation. Rather, it lies in the collective will of both the bar, meaning the association of lawyers, and the bench, meaning the judiciary, to harness this science and apply it with caution and vigilance. No other facet of law and its profession has ever demanded a higher and deeper validation and coordination between the bar and the bench than the need to recognize, determine, and apply AI for adjudication and dispute resolution. I have prepared and posted this note on the Ibani channel to foster further discussion on all of the above matters. Just for your entertainment, as part of this note, I have also included what Google Notebook LM, backed by its gluttonous data consumption, has to say about this commentary. Shekhar Purna, October 7th, 2026.
In 2025, the UK government didn't just allow an AI to help a lawyer. They actually allowed an AI to become the lawyer.
Yeah, it's a pretty massive shift.
Right. I mean, we're looking at the exact moment a machine was granted the actual legal right to sue you. So today we're exploring this sudden and honestly very real collision of artificial intelligence and the global justice system.
It's happening a lot faster than people realize.
Exactly.
Yeah.
We have a really fascinating deep dive for you today. We're drawing on a freshly published commentary piece from Shekhar Purna on the Ibani channel. It's titled The Dawn of AI Jurisprudence and Regulatory Oversight. And it's dated today, actually, July 10th, 2026.
And this piece is just incredibly rich. I mean, it pulls from 3 very distinct monumental shifts that are happening right now.
Yeah, there's a lot to cover.
There is. We are looking at that historic regulatory decision out of the UK. And then a profoundly philosophical judgment passed down by the Supreme Court of India in response to it. Plus, this brand new 35-page draft blueprint that's attempting to regulate AI in the judiciary.
So our mission today is to figure out how courts and regulators are trying to balance the massive, undeniable efficiency of AI with the core human essence of judgment. Like, what does this mean for you and for the future of how right and wrong are actually decided in our society?
That is the big question.
Okay, let's unpack this. We need to start with the spark that ignited this whole international conversation.
Right. So that spark happened when the Solicitors Regulation Authority in the UK, the SRA, granted the world's very first official approval to a fully AI-driven legal services provider.
Wow.
Yeah. It's an entity called Garfield.Law Ltd. And to understand the gravity of this, you really have to look at what the firm actually does.
Because it's not just a chatbot, right?
No, not at all. This isn't just a widget on a website giving you generic boilerplate legal advice. Garfield.Law Ltd. is officially recognized to recover unpaid bills, handle small claims related to debt collection, prepare actual court documents, draft legal notices, and formulate court petitions.
Wait, I have to stop you there. How is that structurally possible? I mean, law firms have historically been owned and operated by humans who passed the bar, right? People who carry malpractice insurance, who have a literal license to practice.
Right.
You can't just give a software program a license.
Well, you can if you leverage a very specific mechanism in UK law. It's called Alternative Business Structures, or ABS.
Okay, what is that exactly?
So if we look at the historical context, the UK introduced the ABS framework years ago, primarily through the Legal Services Act of 2007. And the original idea was to allow non-lawyers to participate in the ownership and management of legal firms.
So like bringing in outside investors or something.
Exactly. The stated goals back then were pretty forward-thinking. They wanted to promote healthy competition, protect consumer interests, and accommodate new business models.
Oh, I see. So people thought this meant, like, a supermarket chain could set up a small legal clinic in the back of the store to help with simple wills or whatever.
Yes, precisely. They were trying to break the monopoly of traditional law firms to make legal help cheaper for the average person.
Right. It sounds like we've gone from using AI to spell check our legal homework to letting the AI actually graduate from law school and open a firm.
That's a great way to put it. Fast forward to 2025, and that exact same structural loophole meant that a team of software engineers and venture capitalists could own a law firm where the primary practitioner delivering the service is literally a large language model.
That is wild.
It is. The ABS structure allowed the corporate entity to be regulated, so they observe the liability, while the AI does all the actual intellectual heavy lifting.
I have to push back here for a second, though. When you say they're handling small claims for debt collection and recovering unpaid bills, I mean, isn't this just an automated money collection machine?
It sounds like it, sure.
Yeah, like, is this really a genuine shift in legal practice or just a glorified, highly efficient billing department generating form letters?
I get why you'd think that. It's easy to look at debt collection and think it's purely administrative. But drafting court petitions and formulating legal notices, that requires applying the law to specific real-world facts.
Right, because every case is slightly different.
Exactly. If someone disputes a debt, the response requires legal logic. How does an AI formulate a court petition without hallucinating? Well, it relies on massive data sets of prior case law. It matches the statistical probability of the user's facts against successful legal arguments.
Oh, wow, so it's actually doing the legal reasoning.
It is. The SRA's approval wasn't just giving a software company a license to operate a search engine. It was a regulatory body officially recognizing a firm that provides legal services exclusively through AI. It basically establishes AI as an official legal entity.
Okay, so the UK proved the technology is commercially and legally viable.
Yes, they did.
But, viability isn't the same as morality, and that's the exact collision that forced the Supreme Court of India to intervene. Which brings us to the core of Shekhar Purna's commentary.
Exactly. This UK development didn't just stay in the UK. It sent ripples globally, and it caught the direct attention of the highest court in India. Purna focuses heavily on the Supreme Court of India's Civil Appeal number 11-1950 of 2025.
And what did they say about it?
Well, what's fascinating here is that the court didn't actually condemn the UK's move. They called the UK's order satisfactory and reassuring.
Wait, really? They liked it?
They did. They openly welcomed AI's extraordinary capabilities. They noted how it motivates professionals to work smartly, efficiently, and expeditiously.
But in the exact same breath, they raise a massive existential red flag about what happens if we leave this technology unregulated, right?
Oh, absolutely. The court draws a very sharp distinction between AI and literally every other technology that has ever entered a courtroom. They explicitly highlighted this in the third paragraph of their judgment.
Okay, what was the distinction?
They noted that reliance on technology for the delivery of justice has never been the issue. Courts have seamlessly adopted technologies for decades, but the story of AI unfolding right now is entirely different.
But, courts have adopted typewriters, digital filing, legal search engines. Why is a text-generating AI fundamentally any different than a really good digital legal encyclopedia like Westlaw or LexisNexis?
Because a digital encyclopedia returns exactly what you search for. It is deterministic.
Right.
Previous technologies were merely tools to assist human beings in their work. A word processor doesn't draft a legal argument, it just records what you type.
Sure.
AI, however, according to the court, is transformative because it acts as a substitute for our own thinking, logic, and decision-making. It doesn't just retrieve information. It synthesizes new reasoning.
But isn't that just extreme efficiency?
Yeah.
If the court acknowledges that AI motivates professionals to work smartly and expeditiously, why is substituting logic such a bad thing if the outcome is correct?
Well, substituting logic isn't just an efficiency upgrade. It's a slippery slope into losing our ethical grounding. We have to look at how a large language model actually processes legal logic.
Okay, how so?
Think of it like a master chef who has completely lost their sense of taste, but they have a massive spreadsheet of what ingredients statistically go together.
Okay, I like this analogy.
Right. So they know that sugar, flour, and eggs usually appear in the same recipes. They can bake something that looks exactly like a cake, but they have no idea if it actually tastes good because they lack the fundamental sensory experience.
Oh, that makes total sense. So the AI knows the statistical probability of the words that make up a legal argument, but it has no actual concept of justice.
And that is the danger. When you allow a machine to handle the logic, you aren't just outsourcing the labor, you are outsourcing the reasoning to a system that doesn't understand the meaning of the words it generates.
Wow.
The Supreme Court of India argued that this leads directly to a very dangerous philosophical dependency. Unregulated use of AI can imperceptibly enter the legal profession and the judicial decision-making process itself. It infiltrates the ethics of our intellectual work.
Imperceptibly. That's the scary word there. It doesn't arrive with a dramatic robot takeover. A lawyer uses it to draft one paragraph, then a whole brief. A judge uses it to summarize a complex case, then maybe asks it to suggest a ruling based on that summary.
Exactly. And this is where we run into a well-documented psychological concept called automation bias.
Automation bias.
Yes. Automation bias is the human instinct to trust machine outputs over our own judgment, especially when the machine provides a confident, well-formatted answer. Our brains are just naturally wired for cognitive offloading.
So if a machine gives us a highly detailed, perfectly cited legal brief, our instinct is to assume it is correct rather than spend 10 hours verifying it.
We naturally seek that comfort. It's so much easier.
Actually, Shekhar Purna included a direct translation of a specific paragraph from the judgment that addresses this exact psychological weakness. I have it right here.
Oh, perfect. Read it.
The court said, and this is a quote, "Wisdom and foresight compel us to recognize the human weakness of seeking comfort by delegating responsibility to others."
Such a powerful line.
Yeah, let me finish it. They go on to say, but if delegating the very act of thinking becomes a habit, it will have serious consequences on the core of human existence. The essence of human existence lies in the capacity to think in discerning the difference between right and wrong, truth and untruth, virtue and vice, righteousness or dharma, and unrighteousness et harma.
It's incredibly profound. They're defining humanity by our capacity to discern truth from untruth and dharma from adharma.
Yeah, righteousness from unrighteousness.
Exactly. They are warning that automation bias isn't just about making factual errors. It's about atrophying the very muscle that allows us to make moral judgments.
It's like relying on a GPS so much that you forget how to navigate your own neighborhood. You just blindly follow the blue line on the screen.
That's a perfect analogy.
But here, instead of losing your sense of direction, you're losing your moral compass. If you constantly let the AI tell you what is legally correct, you eventually lose the capacity to determine what is actually fair and just.
Spot on. When human weakness tempts us to hand over the heavy burden of judgment to these vast, capable systems, we abandon the core of what makes a justice system just.
Okay, so if delegating our thinking threatens our fundamental ability to discern dharma from adharma, and we are hardwired to succumb to automation bias, how does a legal system protect itself while still safely using the technology? Because the UK model is already out there. Garfield.law Ltd is operating. The genie is out of the bottle.
Right, there's no putting it back. So the Supreme Court of India mandated that having absolute and complete human control over the application and use of AI is vital.
Okay.
They use the phrase, staying 2 steps ahead of its application. You have to maintain human supervision at every single stage of adjudication. And the answer to how we do this lies in the newly proposed regulations.
We're seeing the tangible first steps of this right now, aren't we? Shekhar Purna notes that on June 3, 2026, the Supreme Court's AI Committee released a 35-page draft blueprint on how AI should be implemented in the Indian judicial sector. They actually asked for stakeholder feedback on it.
They did, and the court explicitly stated that this issue cannot be resolved merely through judicial mandates or declaratory judgments. You can't just pass a ruling and tell lawyers to be careful.
Right, that never works.
No, it doesn't. You need structural frameworks that enforce that human-in-the-loop requirement.
Let's dissect the mechanics of that 35-page draft blueprint then.
Yeah.
What kind of specific guardrails are they actually proposing to keep us 2 steps ahead?
Well, the blueprint focuses heavily on compartmentalization and auditable trails.
What does that mean in practice?
First, it proposes sandboxed testing environments. You don't just plug an LLM into the live court docket system. You test it in closed loops to see where it hallucinates precedents.
Oh, that makes sense. Keep it contained.
Exactly. Second, it discusses mandatory disclosure protocols. If a law firm uses AI to generate a petition, they must explicitly flag that for the judge and the opposing counsel.
So everyone knows they're dealing with statistically generated text, not just pure human reasoning.
Yes. And most importantly, it mandates strict liability frameworks. A human lawyer must sign off on the AI's output and take full legal and professional liability for any errors, biases, or hallucinations the machine produces.
Wow, okay.
Yeah, the blueprint is trying to structurally force lawyers to read and verify the output. It's deliberately counteracting that automation bias we talked about.
Porna gives a really great humanizing context to this blueprint in his commentary. He mentions that he intended to officially submit feedback to this 35-page draft, but he admitted, with a lot of candor, honestly, that due to a lack of time and age-related inertia, he just couldn't get around to it.
That's very honest of him.
It is, and he notes that because this project is in its nascent stages, this preliminary vision is surely going to have shortcomings.
His admission highlights the exact problem the court is warning about, though. Creating regulations requires immense effort, and human inertia is a very powerful force.
Definitely. Porsen even added this incredibly relatable detail at the end of his post. He mentioned that he actually fed his own commentary into Google Notebook LM just for entertainment.
Oh, really?
Yeah, pointing out its gluttonous data consumption. It just shows how pervasive and accessible this tech already is. Even someone admitting to age-related inertia is casually using advanced AI to summarize their own writing.
It perfectly highlights the paradox of our current moment. The tools are so accessible and the cognitive offloading is so instantly rewarding that resisting them requires massive collective effort.
Which is really hard to mobilize.
It is. And that brings us to the ultimate conclusion of the Supreme Court's judgment. True success won't come just from framing rules. They stated that effectively managing AI requires the collective will and deep coordination of both the bar, the lawyers, and the bench, the judiciary.
Yeah, they said no other facet of law has ever demanded a higher or deeper validation and coordination between lawyers and judges.
If we connect this to the bigger picture, this is a call to arms for the entire legal profession. It's not enough for lawyers to just figure out how to use AI to win cases faster.
Right.
And it's not enough for judges to figure out how to use it to clear their incredibly backlogged dockets. They have to work together to actively govern its integration. They have to collectively agree to harness the science with caution and vigilance.
Ensuring that the human capacity to discern right from wrong remains firmly in the driver's seat, despite the obvious temptation of automation bias.
Exactly.
So what does this all mean for you listening to this right now? Whether you are prepping for a boardroom meeting about adopting new tech or catching up on the latest trends or just insanely curious about where society is heading, this deep dive shows us that the debate over AI has evolved substantially.
It really has.
It is no longer just a conversation about job replacement or economic efficiency. It is fundamentally about who or what we trust to make the ultimate decisions about truth, virtue, and justice. We are watching the dawn of AI jurisprudence, where regulators in the UK are granting AI the power to practice law, while courts in India are desperately trying to build ethical guardrails to protect the human soul of the justice system.
It is a very delicate balance, utilizing the extraordinary capabilities to work smartly and expeditiously, while absolutely refusing to let the machine substitute our own moral logic.
Yeah, and that leaves us with a final provocative thought I want you to mull over today. We talk about the Supreme Court's mandate to stay 2 steps ahead through absolute human supervision and the blueprint's demand for auditable trails. But consider the nature of AI black boxes.
Right, the transparency problem.
Yes. Modern neural networks are non-deterministic. Even their creators often cannot explain exactly how the AI arrived at a specific conclusion.
The pathways are just too mathematically complex for a human mind to manually trace.
So if AI eventually becomes so advanced, so fast, and so mathematically complex that a human mind can no longer fully retrace the AI's logical steps to audit them, will human supervision inevitably become just a rubber stamp?
That is the terrifying question.
If you can't understand how the machine reached its conclusion, you are just blindly trusting the output. And if that happens, have we already delegated the very act of thinking without even realizing it?
That is the existential question every industry, not just the law, is going to have to face very soon.
Keep questioning the information around you. Keep looking for those deeper connections. And whatever you do, don't let the machine do all your thinking for you. Thanks for joining us on this deep dive.